Today's bull session concerns Waqf Amendment Act 2025. Hello friends, this is Advocate Sanjay Arora. I welcome all of you to my YouTube channel Legally Determined. Let's us get started. Waqf in India is a dangerous anachronism in a secular state. Waqf boards among India's top landholders. The armed forces had 17.99 lakh acres in 2022 and the railways 12.11 lakh acres in 2025 and the 39 lakh acres collectively held by the Waqf boards. Out of the 39 lakh acres, 21 lakh acres were added after 2013. Waqf refers to an endowment made by a Muslim for charitable or religious purposes, such as building mosques, schools, hospitals, or other public institutions. Waqf is inalienable. Waqf cannot be sold, gifted, inherited, or encumbered. The doctrine of Cypress, derived from the English law of trust, is applicable to waqfs under Islamic law. The term Cypress means as nearly as possible. The doctrine of Cypress provides a legal mechanism for the continuation of a waqf when its original purpose becomes impossible, impracticable, or has been fully accomplished. Section 3, Clause R of Waqf, earlier WAKF Waqf Act 1995, defines Waqf as the permanent dedication by any person of any movable or immovable property for any purpose recognized by the Muslim law as pious, religious, or charitable, and include a waqf by user, but such waqf shall not cease to be a waqf by reason of only of the user having ceased, irrespective of the period of such cessor. Second is Shamlat Patti, Shamlat Deh, Jumla Malkan, or by any other name entered in a revenue record. Shamlat Deh land is the land that belongs to the entire inhabitants in a village. In contrast, Shamlat Patti refers to the land under a particular inhabitant's confines in a specific area. Jumla Malkan refers to a specific category of common land in the state. Grants, including Mushratul Khidmat, for any purpose recognized by the Muslim law as pious, religious, or charitable, and a waqf alal olad to the extent to which the property is dedicated for any purpose recognized by Muslim law as pious, religious, or charitable, provided when the line of succession fails, the income of the waqf shall be spent for education, development, welfare, and such other purposes as recognized by Muslim law. And Waqif means any person making such dedication. Waqf alal olad is the property dedicated by the Waqif, the creator of the Waqf, to the charitable trust. The Waqif may appoint himself as the manager of the Waqf known as mutawalli. The Waqif or mutawalli ceases to be the legal owner in the eyes of law and remains only the manager or trustee of the property, which is treated as vested in gold. According to the Islamic concept of Waqf, the Ministry of Minority Affairs announces that India's Waqf Amendment Act 2025, also known as UMEED Act, Unified Management, Empowerment, Efficiency and Development, comes into force on 8th April following the issuance of a Gazette notification of India by the central government, ushering in reforms for Waqf property management. The act had received the assent of President Draupadi Murmu on 6th April, 2 days after its passage in Parliament. The amendments, based on the recommendations of the Joint Committee on Waqf Amendment Bill 2024 JCWAB, introduce several reforms designed to improve transparency, efficiency, and control in the administration of Waqf properties. According to the Waqf asset management system interface WAMSI, there are currently 4.02 lakh Waqf user properties out of a total of 8.72 lakh Waqf properties. The Waqf Amendment Act 2025 also concerns with respect to government properties as per the data received on September 5, 2024 from 25 out of 32 states or UTs, Waqf boards, a total of 5,973 government properties have been declared as Waqf properties. The Archaeological Survey of India ASI apprised the Joint Committee that 132 protected monuments have been declared as Waqf properties under the control of the Ministry of Housing and Urban Affairs have also been brought under Waqf management. These embody 108 properties under the Land and Development Office, 130 properties under the Delhi Development Authority, 123 properties in the public domain. Waqf property. A Waqf, also known as Habs or Motme property, is an inalienable charitable endowment established under Islamic law. It is a personal property given by Muslims for a specific purpose, religious or charitable purposes. The Waqf can be formed through a deed or an instrument or even orally. A property can be deemed to be Waqf if it has been used for religious or charitable purposes for a long period of time. Once a property is declared as Waqf, its character cannot be reversed. History of Waqf in India. The Waqfs in India have been legally governed in India since 1913. The Muslim Waqf Validating Act was enacted in 1913. This act was replaced by the Musliman Waqf Act 1923. The Musliman Waqf Repeal Bill 2025 seeks to remove the outdated Musliman Waqf Act 1923, which is no longer effective for modern India. The Central Waqf Act 1954 was enacted post independence to provide for the regulation of Waqfs. The Waqf Act 1995 replaced it. Key issues for amendment in the Waqf Act 1995. First, irrevocability of Waqf properties. The principle once a Waqf, always a Waqf has led to disputes. Second, shabby management and shenanigans. The Waqf Act 1995 and its 2013 amendment did not address the problems such like Section 40 of the Waqf Amendment Act 2013 has been widely misused to declare private properties as Waqf properties, causing legal battles. In Gujarat and Uttarakhand, surveys have not started. In Uttar Pradesh, a survey ordered in 2014 is still pending. Third, no judicial oversight. Decisions by Waqf tribunals cannot be challenged in higher courts. That diminishes transparency and accountability in Waqf management. Constitutional validity of the Waqf Act. The Waqf Act applies only to one religion, while no similar law exists for others. A public interest litigation had been filed in the Delhi High Court questioning whether the Waqf Act is constitutional. The Waqf Amendment Act 2025 introduces sweeping changes in the governance and regulation of Waqfs in India. The matchup between the Waqf Act 1995 and the Waqf Amendment Act 2025. First, in the Waqf Act 1995, Waqf could be formed by declaration, user, or endowment, Waqf alal olad, whereas Waqf Amendment Act 2025 removes Waqf by user and allows formation only through declaration or endowment. Donors must be practicing Muslims for at least 5 years and must own the property. Waqf alal olad cannot deny inheritance rights to female heirs. Second, in the Waqf Amendment Act 2025, any government property identified as Waqf will cease to be Waqf. Ownership disputes will be resolved by the collector, who will submit a report to the state government, whereas in the Waqf Act 1995 there is no clear provision concerning government property as Waqf. Third, the Waqf Act 1995 assigned survey commissioners and additional commissioners to conduct Waqf surveys, whereas the Waqf Amendment Act 2025 empowers collectors to conduct surveys and mandates pending surveys to be conducted as per state revenue laws. The Waqf Act 1995 provides for the appointment of a survey commissioner. The commissioner maintains a list of all Waqf properties by making local investigations, summoning witnesses, and requisitioning public documents. The Waqf Act 1995 provides for a mutawallis caretaker who acts as a supervisor of the Waqf properties. Fourth, Waqf Board is a body under the state government. The Waqf Board works as a custodian for Waqf properties across the state. In most states, there are separate Waqf boards for the Shia and Sunni communities. Almost all prominent mosques in the country are Waqf properties and are under the Waqf Board of the state. In the Waqf Act 1995, the Waqf Board had the power to inquire and determine Waqf property that has been taken away in the Waqf Amendment Act 2025. As far as Waqf Board's composition is concerned, the Waqf Board is headed by a chairperson. The Waqf Act 1995 provides for the election of up to two members, each from electoral colleges of Muslim, first MPs, second MLAs, third MLCs, fourth Bar Council members, one or two nominees from the state government to the board. Mutawallis caretakers of Waqfs with an annual income of 1 lakh Indian rupees above, whereas the Waqf Amendment Act 2025 provides that the board must have two non-Muslim members, at least one member each from Shias, Sunnis, and backward classes of Muslims, one member each from Bohra and Aga Khani communities. Two Muslim members must be women. Fifth, the Waqf Act 1995 constituted the Central Waqf Council to advise the central and state governments and Waqf boards. All members of the Central Waqf Council had to be Muslims, including at least two women members, whereas the Waqf Amendment Act 2025 provides that two members must be non-Muslims. MPs, former judges, and eminent persons appointed to the council need not be Muslims. The following members must be Muslims: representatives of Muslim organizations, scholars in Islamic laws, chairpersons of Waqf boards of the Muslim members. Two members must be women. Sixth, the Waqf Act 1995 provides for a Waqf tribunal to be constituted by the state governments to resolve disputes apropos of Waqf properties. According to Section 6 of the Waqf Act 1995, the tribunal's decision is taken as final in cases of disputes germane to a property's status as Waqf, whereas the Waqf Amendment Act 2025 omits provisions deeming finality to tribunals' decisions. The Waqf Amendment Act 2025 allows appeals to the High Court within 90 days. Seventh, given the composition of the Waqf Tribunal in the Waqf Act 1995, the Waqf Act 1995 comprises three members: a chairperson, who is a state judicial officer not below the rank of a district sessions or civil judge, class 1. An officer from the state civil services, additional district magistrate rank. A person with knowledge of Muslim law and jurisprudence. The Waqf Amendment Act 2025 removes the Muslim law expert and instead embodies a current or former district court judge as chairman, a current or former joint secretary to the state government. Eighth, state government state governments in the Waqf Act 1995 could audit Waqf accounts at any time, whereas the Waqf Amendment Act 2025 empowers the central government to make rules concerning registration, publication of accounts of Waqf, and publication of proceedings of Waqf boards. The SCAG Comptroller and Auditor General or a designated officer can audit the concerns surrounding the Waqf Amendment Act 2025. The amended act infringes upon the freedom of religion as provided by Article 25 of the Indian Constitution and the autonomy of the Muslim community to manage their own religious affairs. Increased government control, namely the involvement of district collectors, can lead to bureaucratic delays and potential judicial executive overreach. The inclusion of non-Muslims in Waqf boards undermines the integrity of these religious bodies. Non-Muslim members may lack comprehensive understanding of the cultural and religious practices of Islam. Many outfits, including All India Muslim Personal Law Board, have voiced their concern that the act was created since their input. Thanks for watching this vid. Break a leg.